Welcome to this presentation in which we're going to start the unit on the Fair Labor Standards Act, the FLSA. So let's begin. We have several topics that we're going to talk about. We're going to spend most of our time talking about the actual statute, and quite a bit that what we'll cover today, and even some what we'll cover in the next lecture, will be about the wage aspects of the Fair Labor Standards Act. The Fair Labor Standards Act really has kind of three different sections to it. The first section has to do with these 4 bullets. So you can see it's the more important for our purposes at least. And this has to do with how wages are calculated. How do we establish the wage rate that this person is going to be paid? How do we decide when the clock starts ticking on that person's wage and when the clock stops ticking on that person's wage? And finally, how do we calculate overtime pay, or to decide even if it's appropriate for this person to earn overtime pay, and how do we make that calculation? So those are some things that kind of relate to the first part of the statute that we're going to talk about today. We won't get through all that in this lecture, but we'll make some good strides. The next topic that we're going to cover that is also in the Fair Labor Standards Act is the child labor law. This is one area of the law that most states have some significant burdens beyond what the federal law requires. Texas doesn't have a lot, but if you do much in other states, you will see that the federal statute is really just a floor, and that many states put significantly greater limitations on how employers can use youthful workers, people under the age of 18. The last category is the Equal Pay Act, which we talked about fairly extensively in our sex discrimination section, so we won't do a very deep dive there. After we're done talking about the Fair Labor Standards Act, we're going to flip and talk about Texas wage statutes. We'll see that for the most part, Texas wage statutes track very closely with what the FLSA requires, but there's a few areas where Texas law is a bit different. I'd like to pause and first of all draw your attention to the word labor. You may have recalled in an earlier lecture that I said one way to keep these laws straight is when you see the word labor, think union stuff, like a labor union, right? And if you see the word employment, think the topic of discrimination. Age Discrimination and Employment Act, for example. Or if you see the word discrimination, think discrimination. So labor is somewhat of a code word for union issues, but this statute doesn't fit that mold. And let me explain why it doesn't. And the reason why I'm sharing this is because you might be like me. Sometimes when I know the reason why something doesn't fit the pattern, it helps me remember that it doesn't in fact fit the pattern. Part of this goes back to the idea of kind of changing social values and changing vocabulary for that matter. And one of the big differences back in the 1930s and 40s, we lived in a very different world. It was a world in which there were people who worked and there were people who managed people that worked. And there was a pretty clear distinction between those categories. And this distinction didn't just play out in the workplace, but it also had powerful socioeconomic implications. There wasn't as much social connections between the manager class and the worker class. And so when we see the word labor, that kind of reminds us of that time period where there was a pretty significant social divide between the groups. The blue-collar population and the white-collar population, for example. And so when we think about those days, the word labor is the word that was commonly used to talk about folks who worked with their hands, who weren't managing other folks. That was the word that was used. Instead of maybe so much using the word employee or worker, the word labor was used, or laborer was used. The main focus back in the 30s and 40s was about union activity. Back then, it wasn't as if there wasn't employment discrimination, but it wasn't what was having the imagination or the attention of the people who were legislating in this area or organizing in this area. The focus was on labor unions. In some cases, the population felt, well, if we have labor unions, we'll see less discrimination. So that may have been a motivating factor, but it was more of an indirect benefit from labor unions, not a direct benefit. As we go into the 60s and 70s and 80s, there was less belief or confidence in the labor movement for good or for good reasons or bad reasons, but for whatever they were, there's just the reality that there wasn't. And so people had the idea of, well, I can't really count on somebody else protecting my rights. I need to have those rights myself. Perhaps some of it had to do with maybe an increased culture of individualism, the idea that people kind of want to be apart from other people, to be considered special or unique or not part of a larger group. They want to stand out and be independent. That kind of idea doesn't work as well within a union or a labor format. And so while there's strengths and benefits to, I guess, both worldviews, perhaps the more independent perspective is the one that is, I guess, more powerful in our culture today than in other movements. So we see the word labor because this statute was passed back when the word to describe hourly paid folks was labor. That was our term, even though it has nothing to do with labor unions. Anyway, that's a long explanation to probably a pretty straightforward example. So let's move on from here. So what is the purpose of the statute? Well, we're going to talk about just the wage part of the statute. So we're focusing not on this category, and we're not focusing on this. In fact, this wasn't even part of the initial statute. We're focusing on these 4 topics. And within this category, we're going to see that the FLSA was designed, actually, well, I guess we're focusing a little bit on this one. So we're going to focus on up here. Sorry about that. So we're not focusing on this one, but we are focusing on this one. So the first one that we're talking about is child labor. We're focusing on the minimum age for workers and what can those workers do if they're under the age of 18. Then we're going to look at the minimum wage that they can earn. What is that component? How much do I have to pay my workers? And then we're going to focus on the rate they must be paid if they work over a certain number of hours. And that's this category. There are additional issues that come up. One of the big ones is, when does the clock start ticking? When do I start earning wages? And when do I stop earning wages? But that's a statutory change that comes down the pike in a bit. Okay, so let's get started. So we talked about our 3 categories: the minimum age, the minimum wage, and the overtime pay. Those were the 3 focuses of the FLSA originally. And you can see it was passed in the 1930s. So that's why it has that word labor in it, even though it has nothing to do with unions. I mean, when I say it has nothing to do with unions, what I mean is this law applies to unionized facilities and it applies to non-unionized facilities. And this was an endeavor that the President, Franklin Delano Roosevelt, wanted to pass. It was designed to help us get out of the Depression. It was part of that New Deal package. One of the things about the FLSA is that it has some pretty significant costs if workers are not in compliance. Now, back in the 30s and 40s, an employer that wasn't in compliance was probably not complying because it thought it could get away with it. Nowadays, many times non-compliance comes up, not so much because the employer is trying to do something sneaky, although I'm sure that happens sometimes, but many times it's because we live in a different world than the world of 1938. I mean, think about it. That was 80 years ago. A couple things have changed since then, right? Certainly things in our economy, certainly the way we interact with work. You know, there was no internet. There weren't this sharp division between blue-collar jobs and white-collar jobs. There's still some assembly lines, but they're less common for folks to work on that. So the lines between these different categories has become much more fluid, and the line between when I'm working and when I'm not working has been blurred significantly. So even though we're living in a different world, we're really dealing with the same statute. And as a result of these changes, sometimes it's hard to apply rules from 1938 to our economy today. And so there are, in many ways, more opportunities for violations, even when we don't mean to violate the law. And as a result, the fines can be very significant. We'll talk about a few of those examples as we go forward that hopefully will shed some light on how this can come up. Okay, so let's review the concept of preemption. We've talked about preemption before, but we talked about this primarily in the context of employment discrimination. We talked about how under federal law, certain employees have rights to certain protections. For example, if I am 41 years old, I am protected from age discrimination. If I'm a woman, I'm protected from gender discrimination. But under federal law, if I'm a lesbian, I'm not protected from sexual orientation discrimination. If I'm a 41-year-old female lesbian, I'm protected from 2 of those 3 kind of categories. But let's say I live in California. Well, I still have the first 2 protections, but California law would also say that I have a protected category, protected status because of my category, because of my sexual orientation. If I'm in Florida and I am under the age of 40, then state law would say that I'm protected from discrimination even though I'm under the age of 40. So the issue becomes, well, what happens when a state law provides greater protection for employees than the federal law? The federal law or the Congress could say, well, no, we're just completely legislating in this area, so states can't pass any laws. If states attempt to provide more protections to employees, we're saying they can't. We're saying we have preempted. We have taken over this entire subject. That's one position that the Congress could have taken, and in fact, the Congress does sometimes take this perspective on preemption. Another position, though, that Congress can take and does take and has taken in this area is when it sets a floor, but it doesn't set a ceiling. It says, listen, all states have to provide this level of protection. So well, for example, the state of Alabama does not have any statutory protection, or at least it hasn't in the past, any statutory protections for discrimination. Does that mean that if I'm an Alabama worker that I can be discriminated against because of my gender or my race or my age? Of course not. I still enjoy all those protections under federal law. And I'm sure that's why the Alabama legislature hasn't passed any laws in this area, because it's kind of redundant, since all Alabamans are already covered by these protections, or at least the vast majority are. So the federal law provides a certain level of protection for everyone, and then states can provide more protection. Well, that's how it works with the FLSA as well. So if our minimum wage, and we'll say that the minimum wage is increased to $9 an hour, well, that's going to apply at that instant in all 50 states. Even a state that has a lower minimum wage, the minimum wage immediately goes up for people who are engaged in interstate commerce, which is the vast majority of workers. But let's say I happen to be in a state whose minimum wage is $12 an hour. Well, that's perfectly lawful. In that state, I need to be paid $12 an hour, even if the federal minimum wage is $9 an hour. So I'm guaranteed $9, but if the state law provides a higher minimum wage, I'm guaranteed that. That's how it works. It's a floor, not a ceiling. That's how it works in discrimination law, and that's how the FLSA works as well. And that's how the idea of preemption works in this context. When we get to ERISA, we'll see an example of a different type of preemption. The first kind I talked about, where there's complete issue preclusion, that the federal government is the only entity that can legislate in that area. Generally speaking, we don't have a lot in Texas where a Texas statute provides greater protection for employees. As a result, for the most part, we look to federal law for wage protections for employees. And if you're working for the employer, you're going to be focusing on federal law. But if you happen to have an employer, or you're working for an employer who has units in multiple states, you'll need to be aware that the answer may well vary significantly depending upon the state in which you're looking into. So we're first of all talk about the idea of employees who are covered by the FLSA. You know, the basis for almost all of Congress's authority to regulate the economy is found in the Commerce Clause to in the U.S. Constitution. And that says, you know, that Congress can regulate commerce between the several states, so basically interstate commerce. Once upon a time, that Commerce Clause language was interpreted narrowly by the courts. And so Congress had relatively little power to affect the economy. And states then therefore reserved that power to regulate the economy and things along those lines. But again, during the Great Depression, while the New Deal was happening, Roosevelt persuaded the U.S. Supreme Court to have a more expansive meaning associated with the Interstate Commerce Clause. We talked a little bit about this when we talked about the heart of, is it the heart of Atlanta or the heart of Georgia? I can't remember which, but that very important Supreme Court case that upheld Title VII. Actually, the Civil Rights Act of 1964, which included Title VII. So the bottom line is, because of this much broader understanding of what the Commerce Clause is, that of course greatly expanded the ability of Congress to legislate and to affect our economy. And so as a result, Congress basically has in many of these statutes, and certainly in the discrimination statutes in the FLSA, have written statutes that are so broad that the vast majority of employees are going to be covered, because the vast majority of employees are engaged in interstate commerce as that term is understood today. Will there be a few workers who aren't covered? Yeah, there will be. Employees of very small companies or employees who really don't affect the larger economy, but those are few and far between. And so as a practical matter, the vast majority of workers are going to be covered by the FLSA. The FLSA covers both part-time and full-time employees. It covers an employee from the first hour he or she works, even if it's only 1 hour. Let's consider this scenario. Unicorn Industries has close to 1,000 full-time and part-time workers who manufacture hand tools. The company policy states that part-time employees are not eligible for overtime pay, even if an employee works more than 40 hours during a particular week. Unicorn Industries has violated the FLSA because guess what? The FLSA's rules about overtime pay apply equally to part-time folks as full-time folks. Now, obviously, in most cases, part-time workers aren't going to work over 40 hours, but that may well not be the case in peak or crunch times for a particular employer. And so all the protections that full-time employees are entitled to under FLSA will also apply to part-time employees. Also, the FLSA applies to temporary employees. Even if I just hire somebody for an hour, that person is an employee and therefore is entitled to all the protections of the FLSA. Let's talk about interns. This is an area of the law that surprises folks and that is a pretty common area that we see lack of compliance. This is especially true when the economy isn't too bad. Workers who can afford to be unpaid interns oftentimes seek out those opportunities because they can make important business contacts, perhaps do an internship that will lead to permanent employment, or at least give themselves some work experience that they can add to the resume. Of course, many people are unable to take the unpaid internships because they need a job. They need to have a line of income, and obviously an unpaid internship is not going to provide that. So what does the law say about this? Well, it is generally speaking not okay for employers to use unpaid interns if the intern is doing any work that is of value to the employer, which is almost always. So if I have an intern who is just job shadowing me, he comes to the meetings I go to, he listens, he sees what I see, and I maybe explain things to him, well, this is why we're doing it this way, or this is why we shouldn't do it this way, but he's really not adding anything to the equation, then it's okay for me to have him. But if I start saying things like, could you type this up, or could you pull that file for me, or why don't you get me a cup of coffee, or what do you think about this proposal? even if it's not a big part of it, even if he's mainly job shadowing me, but there's some of this other stuff. Well, under those circumstances, he needs to be paid, and probably he needs to be paid minimum wage. Now, of course, many times the intern isn't going to turn in the employer, and so the employer can oftentimes get away with this for quite a while. But it may be that that worker, that intern that you thought was going to be awesome isn't quite so awesome. And you thought that you were going to be able to offer him a full-time position at the end of the internship, but you decide you don't really want to. Or the economics are such that you can't afford to. And so now this former intern is pretty angry at you. He feels deceived. Well, if he's very clever at all, he's going to be calling the Department of Labor, Wage and Hour Administration to report you. And once that is reported, he's not just going to talk about himself, he's going to talk about the other 30 interns you've had over the last few years. And so you're going to face not just penalties associated with his internship, but penalties associated with all of those others. So it's a pretty big deal to mess up in this area, and the better course of action is just not to do it. You only have to pay minimum wage. You don't have to pay any higher than that, but you do need to pay that. Anything less than that is a foolish risk to take. You might say, well, we'll just do the job shadowing thing. Well, that might work for a week or a few days, but you know what's going to happen? There's going to be creep. The first week, all the intern doing is shadowing, but that's boring to shadow all the time. And the intern wants to impress. He wants to get a good reference out of this. So he starts thinking of ways he can add value. Oh, let me answer the phone for you, or let me organize that file for you, or let me carry that for you. It's a very natural thing that the intern wants to do. And after a while, the person whom he is interning for starts thinking, well, why shouldn't I take advantage of this? This is kind of stupid that he's following me around like a puppy dog. I mean, he's not getting anything out of it. I'm not getting anything out of it. Would make sense for him to do something more. So under those circumstances, it becomes a situation where it may start being lawful, but after a while, it's not going to be lawful. So my suggestion would be not to use unpaid internships at all. The only time that you probably can use them would be in the context of nonprofit organizations. Let's consider the nonprofit organization. So we have Bob. He is a volunteer. He wants to volunteer, and he wants to work as an intern for Green Dragon International, a nonprofit. And this is the key fact here. Dedicated to environmental protection. Green Dragon hires Bob without any pay. Green Dragon did not violate the FLSA because unpaid internships at nonprofit organizations are generally permissible. That is probably even true even if Bob is doing the similar work that other people are doing for compensation. But let's say Bob is hired into a traditional job, or he is actually earning, we'll say, $10 an hour. Well, Bob won't be permitted to volunteer some of his time and to work some other of his time. He's either an employee, and so all of his effort is going to be compensable at his hourly rate, or he's not an employee at all, and therefore none of it will be compensable. You can't have kind of a hybrid situation. Obviously, the federal law also includes federal, state, and local employees, and it covers domestic service workers to some extent. It covers them in terms of the minimum wage and the child labor aspects, but it does not permit those individuals to collect overtime pay. So if I am employed as your butler in your house and you pay me $10 an hour and I happen to work 50 hours in that week, I'm not entitled to time and a half for the time that I work over 40 hours. Now, certainly I can work that out with you as part of my employment relationship. That's fine between the parties, but that doesn't have to be a component to my wages under the FLSA. The three areas that we oftentimes see activity under the FLSA is, first of all, determining who is a covered employee, who is affected by this. And probably the biggest issue here is this employee an employee, or is this employee an independent contractor? We talked at length about this in another module, so I'm not going to revisit this, but you may recall I said that the FLSA definition is a pretty important one, and that's really what we're getting at here, whether this person is an independent contractor or an employee. The next issue is figuring out how many hours this person worked. Imagine for a second that when I arrive at let's say it's a big facility, a big plant, and where I have to park my car, it's a 10-minute walk for me to get to my workstation. And you know what? Even when I get to my workstation, before I actually get there, I have to wait in a line to badge in, to clock in. And that takes about 5 minutes. And so from the time I leave my car until I'm actually beginning my work is 15 minutes. Well, is that time paid or is that time unpaid? Imagine on top of that I have to put on some safety gear. Maybe I have to change clothes. Maybe I have to put something over my shoes. Maybe I have to put on goggles or something along those lines. Maybe that takes me 10 minutes. So is that compensable time or not? You can see how there's lots of issues with that. Now, on any individual day, the time we're talking about may just be a few minutes, but think about it. That could be every day, and there could be hundreds of employees who are affected every day. And it's impossible for a group of employees to look back in terms of a statutory period for up to 3 years. So these very small amounts of time can really quickly add up to very, very significant cost. And oftentimes another factor of the cost will be that, let's say this worker usually works 38 to 40 hours a week. Well, these extra times, if they haven't been included, and they should have been included, could easily push this employee over into overtime. So this can be a very, very big factor. Another issue is calculating the rate of pay for overtime compensation. Many times this is a very straightforward issue. I happen to work in a job and I earn $10 an hour. And most weeks I work 40 hours a week, but every now and again I work 45 hours a week. Well, pretty easy calculation. For those extra 5 hours, I'm going to earn $10 an hour times 1.5, or $15 an hour for those 5 hours. That's easy to calculate, and that's not an unusual situation. But many times a person will earn more than one wage rate. For example, I might have 2 tasks that I do, and one of the tasks I earn $8 an hour, and one task I earn $12 an hour. For example, maybe I'm a lead person on certain shifts, but not on others. Or maybe I get a shift premium when I work late on Thursday nights, but I don't earn that shift when I work during the day on Wednesdays. Or perhaps I am able to earn a commission at certain points, and I therefore earn an additional amount that particular week. Or perhaps I get a bonus for having perfect attendance or something like that, and it's paid on a particular week. That can affect my the rate that will need to be multiplied by 1.5 times to calculate my overtime rate. So can be lots of interesting issues with that. Does the FLSA apply to a business that for the most part sells and services goods in intrastate commerce, so within a particular state? And the answer is yes. I present this case simply because this is a good example about how broad this statute is and how it's going to capture almost all the workers who work within a state, even if they don't seem to be doing interstate commerce. If you ever are in a position where you think a particular worker is not engaged in interstate commerce, before you make that conclusion, I would definitely recommend that you get a legal opinion about that. I'm going to skip over this case. I don't think this is one that we need to talk about. Or this one. We've already talked about the issue of being an independent contractor, but just a reminder, if the worker is an independent contractor, the FLSA does not apply, so you don't have to pay that person minimum wage. You don't have to pay that person overtime pay. Now again, the FLSA was written in such a way so that the likelihood is that this person is an employee. There's a strong prejudice in favor of the employee designation. This is what's called a remedial statute. It's designed to cover as many people, or it's designed to err on inclusion, the side of inclusion versus exclusion. But that doesn't mean that every single person who's doing labor is going to be counted as an employee. There will be cases where the person is an independent contractor. Again, as we talked about in the other module, this is a really, really complex subject. There's lots of different tests, lots of different case law in this area. They're very fact specific, and in some extent the cases are kind of all over the map. It's hard to see a lot of trends in some of those areas, and so when you encounter this situation, it's a good idea to run it by an attorney before you make any conclusions one way or the other. Designating someone as an independent contractor when they should have been designated as an employee doesn't open up the employer to very significant fines. And that can be multiplied by the number of people that you have that designation. Maybe you happen to have 100 people in your workforce and they all fit into that same category. Well, the fine for one person might not be so awful, but if you multiply that by 100 and you go back 3 years and maybe you have double damages, you're thinking about possibly hundreds of thousands, even millions of dollars under those circumstances. So a misstep in these areas can have very, very significant implications. Again, here's some information, just a refresher about the idea of independent contractor. I'm not going to revisit this since we talked at length about this earlier. This is an interesting case. This is back in the 1980s, where there was perhaps less of a focus on undocumented individuals. In this case, Mr. Patel was in the United States without the correct documentation. He was working for a hotel, and he was not paid all the wages he was entitled to. Well, the hotel said, wait a second, or when Mr. Patel sued it, the hotel said, wait a second, you weren't supposed to be working at all. So we shouldn't have to pay you any of this money that we really do owe you, but we don't owe you, I guess, because you were not eligible to work. Well, the court said, no, you still have to pay Mr. Patel even though he wasn't eligible to work. I don't know that we'd have this result today because there's definitely been a cultural change in this area. So that's why I'm not going to ask you to know this particular case. I'm also going to skip over this one as well. So let's look at what the remedies are. What will the damages that a successful plaintiff will get? Well, lost wages, whatever the person would have earned if it had been calculated correctly. So if he isn't paid minimum wage and he should have been paid minimum wage, it's whatever he earned less than minimum wage, that difference between minimum wage and whatever he earned less, timed by however many hours the error happened. If it is a case where his overtime pay was not calculated appropriately, then what would the correct calculation have been? He would also be entitled to the fees associated with his representation. Court costs, these are things like the cost of deposition, the cost of filing the lawsuit. Oftentimes these run in the $10,000 to $20,000 range. So this attorney's fees well, the lost wages is usually the single biggest amount. Attorney's fees, though, can actually be more. Court costs are a relatively small piece of this equation. And then we have the potential for something called liquidated damages. The name is a little bit maybe surprising. It's a legal term that its name doesn't really, to me at least, suggest what it's about. This is a term that means it's kind of a preset or pre-established amount of damages. It's the equivalent kind of punitive damages, but instead of having the jury decide exactly how much punishment the employer needs, the statute itself tells everyone this is the degree of punishment you ought to levy against the employer in these situations. And what it is it's double the damages that exist. It's double the lost wages. So if lost wages are $50,000, then you're going to double is to get the liquidated damages. So we're talking $100,000 under those circumstances. And these are available, and also the attorney's fee. So all of these you add all these up, and then let's say the total amount for these is, we'll say $120,000. Well, then you're going to add another $120,000, and that reflects the entire amount of damages that the defendant's going to have to pay. In this case, $240,000. But the liquidated damages are available only in willful cases. So what is a willful case? Well, this is when the employer knew or should have known what he was doing was illegal. So if there was a reasonable interpretation of a statute and the employer was following a reasonable interpretation, even though he was mistaken, what he was doing was a reasonable way of looking at the law and reasonably interpreting things, then he's only going to have to pay this first amount if he was ultimately wrong. But if the position they took was unreasonable or intentional, he knew very well he was violating the law, then he's going to have to pay the larger amount. A statutory period also varies depending upon willfulness. So it's 2 years if it's not willful. It's 3 years looking back if it's willful. Many times FLSA cases are class actions, meaning you don't have just one employee. You might have, 100 or 1,000 employees in this category. And they may not all currently be working for your for the employer. Maybe some have left, some have come. Maybe there's that person, maybe of a department of 100 people. 99 are happy, but you just have that one disgruntled person. And aren't you always going to have in a group of 100 people at least one disgruntled person? And that person is terminated, or maybe they're not even terminated, but they call the Department of Labor, Wage and Hour Administration, and an investigation starts. The 99 who are happy never would have called. But guess what? The Wage and Hour Administration is going to find a violation in their circumstances too. So you're always, living on the edge if you decide to follow practices that are potentially unlawful. And of course, many times these will be class action type situations. So the willfulness, so you may be thinking, well, how likely is it to get a willfulness finding? A willfulness finding is by no means automatic, but I would say more often than not, if the plaintiff can prove a violation of the law, he or she will probably be able to prove willfulness. I don't have a percentage as to, is it a 70% chance or 60% chance or 80% chance? It's probably somewhere in that range. I would say it's more than 50, but certainly less than 100. And of course, it's going to vary from fact to fact. But in these cases, typically the employer isn't thinking to himself, oh, we're gonna lose, but we're not gonna get a willfulness finding. I mean, you hope to win completely. If you have to lose, you hope to lose, but without a willfulness finding. But unfortunately, willfulness findings are not unusual in these cases. So here's a surprise for many folks. Federal law doesn't regulate lots of aspects of the kind of wage and hour situation. For example, it doesn't require employers to provide any vacation, any holidays, any holiday pay. There's no requirement that it provide any kind of severance benefit or any type of sick pay. Moreover, federal law doesn't require any type of meal periods or rest periods. It doesn't require any type of premium pay for holiday work or weekend work, or it doesn't require any type of discharge notice. It doesn't require that a reason for discharge be given. It also doesn't require that wages be paid after a certain period of time after the discharge. Generally speaking, there's no cap on the number of hours that an employee can be forced to work, unless, of course, that employee is very young, so the child labor protections apply. An employee doesn't have the right to turn down overtime. There's no rules about a certain pay raise schedule or fringe benefits or anything like that. So the level of protection beyond the minimum wage and the overtime pay is very sparse under federal law. Now, many of these things are routinely given to employees by large employers or even middle-sized or small employers. And that can be a very smart decision for that employer because, after all, employers aren't thinking strictly about legal compliance. They also want to attract and retain the best workers. And these are important tools to use for those purposes. It is true that in many states, some of these things can be required by law, especially the second bullet, meal breaks, rest breaks, holiday pay, vacation time. Those can sometimes be required by state law. Not in Texas, but in other states. Now, again, I'm not suggesting that you somehow eliminate meal breaks for your employees who work an 8-hour shift. They're not going to be very productive after a while if they're hungry. Same way with rest periods. It makes sense to allow folks to have a few minutes to stretch their legs and clear their heads. So these are good and smart practices. Just because they're not legally required doesn't mean you ought not do them. And of course, if you're working for an employer who has multiple states in which it has employees, you'll want to make sure that you're familiar with the requirements in the state. California is an especially onerous state in these areas. There's lots of very demanding rules about how you handle especially rest periods and meal periods in California. It's very, very easy to innocently and inadvertently run afoul of those laws and face very significant fines. As we said before, the employee gets the broadest protection. So if the state law offers more protection, the employee gets that. If the federal law offers the greater protection, the employee gets that. Let's consider this scenario. So Bob's a cashier at the discount store located in Wyoming. He's paid the minimum wage that is set by the state law. In Wyoming, unfortunately for Bob, the state minimum is less than the federal minimum wage. If Eager Beaver pays the state minimum wage instead of the minimum wage established by the Fair Labor Standards Act, it's almost certain that Eager Beaver is in violation of the FLSA because the federal minimum wage supersedes or preempts the state minimum wage as long as Bob is involved in the interstate commerce, which is almost certainly the case. We already talked about how Texas law really mirrors the FLSA. Usually, Texas will raise its minimum wage law at the same time that the federal minimum wage law goes up. Now, could Texas have a higher minimum wage than the federal? Absolutely. Depending upon the local rules of various cities within the state of Texas, it's even possible that individual states could have higher minimum wages. And under those circumstances, then that would be what would apply to that particular employee. But for the most part, this is not a very fertile area for litigation in the state of Texas. We'll talk more. So here are some things that state laws often interact with or often do put requirements on employers. We already talked about the vacation, holiday, severance, sick pay, meals, and rest periods. But this is one area that I wanted to flag. We'll talk more about this later on. But Texas does have a statute that addresses the issue of the final paycheck when the employee is terminated. And so I'll fill in the blanks when we get to that. But this is one area where you do need to be aware of this when you are terminating an employee. Many states require, I think California certainly has a demanding statute. I think what California requires is that payment be made immediately. So if I'm firing Bob, maybe Bob stole from me and I caught him red-handed. I want to fire him right there. But if I fire him at 2:30 p.m. on that day, I have to pay him everything that I owe him at 2:30 that day. Well, that presents many times logistical issues. I mean, someone has to be able to calculate how many hours Bob has worked, what his pay rate is, to handle all of the deductions like FICA and other taxes, and to issue a check. To do all of that in a relatively short period of time, that's quite tricky, and many times units, especially if it's a relatively small unit, may not have the authority to cut checks. And you probably don't want to give out that kind of cash. And so for those reasons, and this is again the rule in California, and other states have sometimes very similar rules, although they usually give a little bit of time to the employer. A strategy to resolve that is not to fire Bob right away. Do you know you're going to fire Bob? Of course, you caught him red-handed trying to steal from you. But what you do is you send Bob home and say you're going to conduct an investigation. I mean, you are going to conduct an investigation. You're going to look into the matter, and then you're going to render a decision. But you know what? In the interim, you're going to submit the paperwork to get that check. And let's say that you send it off to corporate, and 3 days later, you get the final paycheck for Bob. Well, that's when you fire him. You call him in, hey, Bob, we have concluded our investigation and we have concluded that you ought to be dismissed. So here's your final pay. So you can see that California law in some sense it is a protection, but it really ends up being kind of a toothless protection for savvy employers, because Bob's going to get the check the same time that he otherwise would have. It's just requiring it paid on the same time just means you're delaying when you're communicating the dismissal decision. I'm sure there are some less savvy employers though that have been caught by this, who go ahead and terminate Bob, then wait the 3 days to get the paycheck cut. Then Bob files a claim with the state agency. The employer may now be being fined, even though Bob is the thief. So you can see how thrilled an employer would be under those circumstances. So we have covered that first module, the overtime, an overview and the coverage of the statute. In our next lecture, we'll talk about minimum wages, overtime pay, and other topics. I thank you for your attention. If you have any questions about this material, as always, please feel free to reach out to me. I love to hear from you and hear what questions you have and what your concerns are about this topic. My email is cgroover@collin.edu. Even better, though, than reaching out to me in email is stopping by my office hours. Usually I'm able to have both face-to-face and virtual office hours. I would love to talk to you in more detail about these topics. Thanks so much for your attention, and I hope you have a wonderful day.